So someone asked you to be their executor, and you said yes. But do you know what that entails? Hi, Nancy Beaubear here with a Gappy and Next Steps. The way things work is usually somebody that you love, a family member, a close friend, will ask you if you are willing to act as executor for them when they pass away, be named on their will as their executor. But often, people don't understand the implications of that role. Neither the person who's asking you to act as the executor, nor the person who is accepting that role. It just seems like the right thing to do. You love somebody, they need somebody to make those decisions, and so you say yes. But did you know that there is actually legal obligations if you do accept that role? Now, I'm not saying this to try to scare anybody. It is a role that really is very fulfilling. It is extremely time consuming, and it's an act of love that you can give to somebody after they've passed away. But you should be aware that there is a fiduciary standard, and under Canadian law, there are certain requirements. What it means to act under Canadian law as the executor is that you're being held to a standard of a reasonably skilled person acting in a fiduciary capacity. Now, granted, that sounds like quite a mouthful, but let's talk about what that actually is. So there's a number of different components when you're acting as an executor that is the standard you're going to be held to. One of them is that you are acting in a fiduciary capacity. Now, what that means is that you have to put the interests of the deceased and the beneficiaries ahead of your own interests. That means that you're not going to be acting the way that you might interpret something, but you have to act in the way that was intended by the deceased when they named you as executor. Above and beyond what is permitted to you as executor within the confines of the will, which may be that you are also a beneficiary, but also can include compensation as an executor through the executor fees as allowed in your jurisdiction. But above and beyond that, you cannot profit from anything. That means that you can't be making decisions about who of the beneficiaries is going to receive what, and you're obligated to stick with what the will states. You also have to adhere to timelines. On the one hand, it's easy to say that settling an estate has its own timeline because they can drag on forever. But in reality, you're settling the estate does not have their own timeline. Settling the estate has a number of legal steps that you have to go through, and there's no way around it. You have to file the final tax return. You have to make sure that you have secured the assets. Sometimes there's assets that need to be sold, like a house. You need to get a grant of probate in most cases. And all of those things take time, and those timelines are dependent on how busy the court is in the jurisdiction that you're filing for probate. Once you get that probate, how long it takes to potentially sell any of the assets that need to be liquidated, identifying all of the debts, making sure that they're reconciled, and of course the taxes. You have the final T1 that has to be filed in many cases, there are additional filings that have to be done depending on the complexity of the estate. Sometimes there's a T3 trust filing that has to be done. There are a number of different kinds of tax returns that can be done. But then getting that tax return sent in and compiled and receiving the notice of assessment is all required, after which time then you apply for the clearance certificate, and that also can take time. Now, one of the things that a lot of people don't understand is with this fiduciary duty, you do have that potential liability out there. If beneficiaries deem that you have acted inappropriately, they can go to the courts, and if they go to the courts, then that can not only just delay the closing of the estate, the settling of the estate, but if the court finds that you did act inappropriately, you could be held financially and legally obligated to repay things. There's a recent case earlier this year in BC, and the executor claimed a number of expenses to the estate. The beneficiaries took this person to court, and the court found that all but $10,000 was inappropriately charged, and the executor had to pay that back. Even though it was probably well-intentioned, you have to be so careful. You have to keep track of every dollar that goes in, every dollar that goes out of the estate, and you have to pass on the accounting to the beneficiaries. Now, that can be done in one of two ways. You can either go to the courts and have what they call the passing of the accounts, or you can provide a final accounting to the beneficiaries along with a consent and release document that they sign that says that they're satisfied with that financial reckoning and that they will waive the court passing of the accounts. Now, once upon a time, we didn't give a lot of thought to this executor role. It was something that somebody asked you to do, and everybody would just say, yeah, okay. But now, more than ever, there's starting to be more and more litigious actions in the settling of estates. And that could be for a number of reasons. Part of it, I think, is that estates have more value in them, and people are more cognizant of the fact that maybe they're missing out on something. The other thing is that estates are more complex and people don't understand the role that they're in. That's why it's important. You don't have to be an expert in any of these fields. You have to be a reasonably competent person. You have to know how to work things through. You have to be structured and organized and have certainly basic knowledge. But you also have to understand when to bring in the professionals, the accountants, the tax specialists, the legal team that is going to help you get through the settling of the estate. So all of this is not to say don't be an executor for somebody, but it is meant to tell you to do it with your eyes wide open and understand what's going on. Now, I'm a certified executor advisor, and I've done this a number of times. So what I did is I created a couple of tools. Over on my website, I've got Before You Say Yes, and that is a reflection, a self-guided reflective tool that will walk you through different scenarios that if somebody has asked you if you would be executor, it gives you a moment to understand what the role is before you say yes. The other tool that I have is called the Executor Standard, and that actually walks you through real-life scenarios that a fictitious executor is going through, and it will ask you what it is that you would do and will advise you on what is the more appropriate way to go. I've also got an article about this topic over on the website. I've got links for all of those items over in the description box. Thanks very much for joining me this week. I look forward to sharing more with you next time. Bye for now.